230 years and 5 days ago, Congress ratified the Bill of Rights, which consisted of 10 of James Madison's 12 proposed articles of amendment to the United States Constitution. The seventh article was originally proposed as two separate provisions, which were merged to read, in full, "No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces, or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation." The amendment introduces the double jeopardy clause, which prohibits defendants from being prosecuted again for the same crime in several circumstances, and also ensures the right to refuse to answer questions that might expose oneself to an accusation or charge of a crime, otherwise known as pleading the fifth. The Supreme Court ruled in Miranda v. Arizona 1966 that statements made by an individual can be used at trial only if they are made after the individual has been informed of their Fifth Amendment right against self-incrimination. The individual has understood that right, and the individual has waived that right. The disclosure of this right has since become known as a Miranda warning, the administration of which is known as Mirandizing. The court also ruled in Berghaus v. Tompkins 2010 that merely remaining silent does not constitute an invocation of Fifth Amendment rights, but that the right to silence must be explicitly and unambiguously invoked. The amendment also introduces the first appearance of the Due Process Clause, which later appears in the 14th Amendment, and which is further elaborated in the provisions of the 6th Amendment.